Thank you so much, Becca, and good morning, good afternoon, or good evening, everyone, and welcome to this webinar, Immigration Benefits for Military Connected Survivors. Before we get started, if you would like to take a moment to write in the chat and introduce yourself, maybe your role and where you are joining from, that would be great. So my name is Dr. Ava Ramirez Ene, and at NOVA, I am the Military Coordinated Community Response Senior Program Manager. I'm joining you from Southern California. I am also joined by my amazing colleague, Kimberly Henry, who is located in Texas. So a gentle reminder for everyone today, please feel free to use the chat for any content related communication, Q&A for questions, and please ensure that any communication is professional and trauma informed and respects each person here. And if at any time you need to take a break or step away, please do so. And with that, I am honored to welcome Leah Ocasio and Christina Velez with Assista Immigration Services Assistance.
Thank you, Ava, and thank you all for joining us here today. Again, my name is Christina Velez. I am the Legal and Policy Director at Assista, where we work on behalf of immigrant survivors of violence and gender-based violence, including domestic violence, dating violence, sexual assault and stalking, and trafficking. We are here today to share some information with all of you about advocating for military-connected immigrant survivors. Thanks very much. Let's get started. Next slide, please. Great. So as was said earlier, we're here to provide a thorough review of immigration options for military-connected immigrant survivors and challenges faced by immigrant survivors who in accessing services and protections. We plan to speak with you today about how to best support military-connected survivors who are undocumented or whose immigration status is uncertain or tenuous. And finally, we will discuss enhanced safety planning and advocacy strategies to help survivors at risk of immigration enforcement. We will also be talking about some of the fairly recent still in the last several years, immigration policies that benefit immigrant survivors. Next slide, please. Thank you. So we're going to get started here with a couple of polls so we get to know a little bit more about who's in the audience. So our first poll here is, have you worked with immigrant survivors? Can we run the poll? Okay. There we have, the poll is up. So folks, there's a second question also included in the poll. Are you familiar with immigration benefits for survivors of domestic and sexual violence? The options are yes, no, a bit, but I'd like to know more. So A is yes, B is no, C is a bit, but I'd like to know more. For the first question, have you worked with immigrant survivors? The answers are yes, A, yes, or B, no. Thanks for sharing the results. It looks like about evenly split, I would say, 50, although a little bit more of you, 57%, have worked with immigrant survivors before. Again, about 47% say that they are somewhat familiar with immigration benefits for survivors, but would like to know more. And a pretty large portion of you both answered no, that you haven't worked with immigrant survivors, and that you're not familiar with immigration benefits for survivors of domestic and sexual violence. Thanks. For those of you who are familiar with these benefits and you have anything to add to the conversation as it's going, please feel free to add that in the chat or in the Q&A. Thanks. We'd love to hear from all of you. Next slide, please. All right, so who are military-connected immigrant survivors? This slide looks like a poll, but it is not a poll. It has checkmark boxes, but it's not a poll. This is a list of people who are included in the description of military-connected immigrant survivors. They include active duty members of the military. They include veterans. They include National Guard/Reserve members and family members of all of the above who have experienced domestic violence, sexual assault, dating violence, trafficking, and stalking. So as noted at the beginning here, we will be focusing in on immigration options for family members, primarily, who are undocumented and who have experienced one or more forms of domestic and sexual violence. Thanks. Next slide, please. Great. So before we get into specifics, I wanted to talk a little bit about which agencies are responsible for adjudicating immigration status and what are the sources of law and guidance for immigration status. As far as the agencies that adjudicate immigration status, the one we work with the most when we do affirmative filings, meaning when we fill out a form and put together a package and send it into the immigration agency, is the United States Citizenship and Immigration Services. The next, which is the Executive Office of Immigration Review, which also means the immigration courts, also called, it's usually called Immigration Court, but it has this acronym of EOIR for Executive Office of Immigration Review. That is an agency made up of, it falls actually under the Department of Justice, and it's made up of administrative judges who are hearing cases of removability that are being brought against undocumented immigrants or undocumented non-citizens in the United States. In the context of EOIR, when we make an application for immigration relief, sometimes we make it to the USCIS, but sometimes we make it directly to that administrative law judge. And those applications are called defensive applications. This is not really that important for you to understand for the purpose of this training, but it's a little bit of background. And when you hear people talk about affirmative versus defensive forms of relief, they're talking about which agency they're approaching for relief. Another agency that we frequently deal with is the Department of State. And the Department of State handles consular processing. So when immigrants or non-citizens are applying for visas to come to the United States, when they are outside of the United States, they go to consular offices located either in their country or a nearby country to process those requests. And so people who have been approved for visas at consular offices abroad will have in their passports a stamp, a visa stamp showing what category of visa they've been approved for and for how many entries, and they'll have the picture and everything. So the Department of State does adjudicate some of those requests, although part of those requests may already be decided by USCIS. But the issuance of the actual visa happens at consular offices. Sources of law and guidance for this work: the USCIS policy manual has the most up-to-date interpretations of immigration law and how it's being implemented at agencies such as the USCIS, and in some cases, the Immigration Court as well. The Department of Homeland Security policy guidance also exists for the same purpose, to give guidance to the people working in those agencies as to how to address certain immigration issues or issues that are laid out in the statute and regulations. And now we come to the statute, right? So the Immigration and Nationality Act, otherwise known as the INA in shorthand, which includes the Violence Against Women Act, which is shortened to VAWA, and the Trafficking and Victims Protection Act, which is shortened to TVPA. VAWA and the TVPA are where VAWA self-petitions, U visas, and T visas are located, but they all are part of the larger Immigration and Nationality Act, which also includes various other provisions that impact immigrant survivors as well as other non-citizens. such as grounds of inadmissibility, grounds of removability, provisions related to naturalization, etc. Next on the list is the Code of Federal Regulations, shortened to the CFR. That includes regulations that implement the provisions of the Immigration and Nationality Act. They are stronger than policy guidance, but policy guidance may still be required to interpret those regulations. And finally, the U.S. federal courts will issue decisions related to immigration status that control decisions made about non-citizens by the above agencies in whatever circuit is covered by a given federal court, circuit or area of jurisdiction. Obviously, the Supreme Court decisions govern all the courts and all the agencies. District courts and courts of appeal decisions may have slightly smaller impact depending on how large the area of jurisdiction is for them. But because immigration is a federal law, it is a federal practice, and so questions about interpretation are often resolved by federal courts. We do not go to state courts, in other words, to interpret the Immigration and Nationality Act. Okay, next.
All right, so I'll do a quick note here about the unauthorized practice of law and avoiding that. So what is unauthorized practice of law? Often used in shorthand as UPL. And so that is when someone isn't a licensed attorney or DOJ accredited representative and they provide legal advice or complete immigration forms. So what does it mean to provide legal advice? That is telling them what to apply for, like simply telling someone, hey, you're eligible for this form of relief is legal advice. Filling out the forms. So here there's a gray area where if someone asks like, hey, what do I put in this box? And it says that box is where you put your name and that's all you tell them, not legal advice. But if you start interpreting the questions and telling them how to answer, that does fall under the practice of law. And the only individuals who can do this are licensed attorneys and DOJ accredited representatives who function as attorneys because they're accredited through the Department of Justice to do so. Immigrant survivors can represent themselves pro se, so they're not going to get in trouble for practicing law by filling out their own forms. But anybody else, theoretically, there are usually laws and policies to not practice law unauthorized. So you want to be careful about what information you're providing to those who are asking questions and err on the side of caution, and then be prepared to refer people to reputable immigration practitioners so that they can get this legal advice and answers to the question that will probably involve law practice. If you're not an attorney or a DOJ accredited rep, there's still a lot of things that can be helpful to survivors in these cases. So documenting the abuse, making these referrals. We're obviously focused on immigration, but oftentimes there are other needs, whether that be housing, public benefits, family law. And so those referrals can be very vital to getting them to achieve justice in the way that they want. Letters of support can be helpful. And a really big thing is accompanying a survivor to court or to USCIS or anything that could be re-traumatizing for them to have that support. If you're going to be working with the representative on the case, make sure there are appropriate releases signed so that you and their representative can speak about their case. I'll pass it back to Christina.
Thank you, Leah. Next slide, please. And the next slide. Okay, so here we're in this section, we'll be talking about what barriers to accessing services we see for immigrant survivors, exist for immigrant survivors. And these barriers, which include cultural factors, legal factors, systemic factors, and language access, those are the factors that are listed on the slide, these are not listed in order of importance or prevalence, by the way, but these are the types of factors which we'll see in action in an upcoming hypo. But here, what I want to note at the outset is that when we talk about cultural barriers in the form of gendered expectations or limited autonomy, can too often be posited as a primary reason why survivors do not reach out for help or support. And that can obscure some of these other barriers, as well as enforce negative cultural stereotypes about people from what are perceived to be more conservative cultures. More often, there are cultural norms that do intersect and are compounded by the barriers of language access, lack of access to legal systems, and also systemic biases that disproportionately impact Black survivors, people of color, and LGBTQ survivors of all immigration statuses. All of these societal and systems barriers are commonly exploited by abusers to control their partners. And we'll look at some of the particular ways that occurs for immigrants. Next slide, please. Okay, so I know that many of you are probably accustomed to seeing the power and control wheel that was developed by the Duluth Project so long ago. I have a link to that here, and I'm putting it in the chat. That's the original, I guess, power and control wheel, but that shows the different ways in which abusers exert control over their partners, their intimate partners, or the people who they are abusing. It includes like descriptions of coercion and threats or intimidation, emotional abuse, economic abuse, use of male privilege, use of children, using isolation, controlling. That's one that we see also very commonly, controlling what the person does, who they see, who they talk to, what they read, where they go, minimizing and denying and blaming. All of these are also happening in a relationship where the abuser the person being abused is a non-citizen. I want to specify also that we're not just talking about couples in which the abuser is a US citizen. Very often, many people experience abuse in relationships where both parties are non-citizens or both parties are undocumented. But the point of this slide and what I wanted to show here is how immigration forms another layer of power and control tactics that are used in abusive relationships. There may be other layers connected to other forms of difference and vulnerability, such as race, disability, and sexual orientation, or gender identity that come into play. But what we have here is, and I'll put this in the chat as well, is the immigration wheel. So I would like to share that here. And I'm also going to share a link that has both English and Spanish versions of this. And I believe that all of this is going to be in your materials as well. But if you're looking at them while we're talking, that's great. Okay, so for immigrants in particular, we can go to the next slide. I believe that has a better list of what I'm trying to show. Thank you. So as is included on the wheel that we saw a minute ago, some common forms of immigration status related abuse are on the slide. They are withdrawing or threatening to withdraw immigration papers filed for residency. That is especially common when we're talking about an abuser who is a US citizen. It's a very common and very effective way of controlling an abused spouse who is a non-citizen is by making them believe that the only way that they could get immigration papers is by cooperating with an abusive partner. Forcing or coercing victims to do something that jeopardizes their status, threatening to call ICE to get victims arrested and deported, telling victims that the police will arrest them because they are undocumented if they call the police for help. All of these are extensions of that sort of exploitation of immigration status differentials. Hiding or destroying important paperwork. This is a very important thing that we see that prevents abused survivors from exercising autonomy by leaving or moving away from the abuser, making threats to family members in the US or abroad, convincing them that they have power to reach family members who are abroad. These are very common tactics, unfortunately, that we see of immigration status related abuse. Also, which was on the wheel that was on the last slide, are things like keeping the person isolated in a language group. So not allowing them to speak with people who, or learn English or learn how to communicate with people outside of their language group. And other things. I don't know if anyone here has anything that they want to suggest. Also in the chat, feel free, and I will read it out. Name calling is another very common tactic that we see employed by abusers of non-citizens. Name calling that connects to their cultural background also is very common that we see. Let's go to the next slide. Here we are going to talk about this hypo, and there are two slides here. Sorry for the ambient noise. I live in an area with a lot of sirens. But so this is a hypo which we will be returning to in another part of the presentation, but I wanted to give you all a chance to read it through and think about this fact pattern as we talk about forms of relief a little bit next. So this hypo has to do with Laura. Laura is from Honduras, and she came to the United States in 2013 with her 7-year-old son, Jose, because Jose's father was abusive to them both. She met Robert, an Army private, and they fell in love and had a daughter named Alana in 2016. Robert would not let Laura go out unless he was with her. He became physically abusive toward her and said that if she called the police, they would arrest her because she didn't have papers and she'd never see her daughter again. After an incident where he hit her in the face in front of the children, Laura left for her friend's house, and her friend, I think it was, yes, took pictures of her bruises and urged Laura to call the police. Thank you. Let's go to the next slide. Here are additional facts, right? So when we first meet Laura, maybe she tells us what she told us on the last slide. This is her general situation. Laura tells you that she's worried about contacting the police because of Robert has told her about being arrested for not having papers. Laura is also doubtful about whether the police would do anything about the violence since Robert is in the Army. She's also worried about going to a shelter because she doesn't know whether they'll help her because she's an immigrant. And Laura would also like to get a protection order and seek custody of her children, but is afraid to go to court. So what these additional facts show are the power of the difference in immigration status that Robert, as the citizen, is exploiting in order to control Laura. Given especially, I think, the messaging that's, I think, depending on especially where Laura is living, but the messaging that Laura may be hearing from the news or from other community members about immigration enforcement may reinforce some of the things that Robert is telling her. So it's going to be incredibly difficult for her to move past some of those fears because they seem very rational in order to seek assistance. So these are all the things that might be holding Laura back. And also, Elisa in the chat, thank you for adding your comment. You sent it to hosts and panelists, so I'm going to read it for the recording and for everyone else. Elisa says, I find that they withhold financial assistance for school and also threaten that they will no longer provide help to their families. Those are in other ways, additional ways of exerting control over non-citizens in relationships. Thank you, Elisa. Let's go to the next slide, please. Okay, and I think as I've been talking, I am thinking about how also, I guess I'm trying to express how immigrant survivors are impacted by increased news of immigration enforcement. Again, how powerful it can be for abusers to use this information in order to control their partners. In 20 advocates, including Asista and our partners at Tahare Justice Center Esperanza United, and API GBV conducted a survey together with the hotline of advocates during this period of increase where we were starting to see increases in immigration enforcement, and in this period where there was a lot of rhetoric, very strong rhetoric about immigration enforcement. We found as a result of the survey that 3 out of 4 advocates reported that immigrant survivors had concerns about going to court for a matter related to the abuser or offender, and that immigrant survivors were sharing that they had concerns about contacting the police. So these numbers, and we did a second survey in 2019 that showed very consistent numbers. What these numbers really show are the prevalence of concerns on the part of immigrant survivors. And although these numbers did certainly go up in times of increased enforcement out in the communities, they remain high even in times where there is different kinds of messaging going around. Although I think once this happens, it's very difficult to undo. So once this happens, it's out there, but even in times where there isn't as much active enforcement, or there are some additional protections in place, such as the ones that exist now that we'll talk about a little bit later. Okay, let's go to the next slide. And thank you also, Marianne, for noting in the chat that you've heard this, but that, like, assuming that you've heard that these responses from immigrant survivors exist, but that your community coordination response does a good job of dispelling them. Thank you for doing that. That's what we're hoping also happens as we go through this training. Okay, so true or false? This is, again, not a poll, something you can answer in the chat. You can let us know what you think. True or false? Immigrant survivors can, number 1, have their perpetrators criminally prosecuted. True or false? True. True. Yes, I guess that's not news to anyone, but yes, it is true. They can more accurately file complaints with police about the abuse that they've experienced, and the police will conduct an investigation and may prosecute their perpetrators. Doesn't necessarily mean that the survivor themselves has the power to make this so, but they can certainly make complaints about their abusers. Immigrant victims can obtain community-based services necessary to protect life and safety. True or false? True. Thanks, everyone. I'm glad to see this. Immigrant survivors can obtain protection orders. True or false? Lots of truths. Thank you. And they can absolutely access shelter and domestic violence services and seek child custody and support, although there are all these barriers that I talked about at the beginning of this section still impact how successfully they can do this. So still impact how successfully immigrant survivors can obtain protection orders, can get child custody and support, can access shelter and domestic violence services. Some areas do not necessarily make those services as accessible to undocumented people as we'd like. And it does impact like how police respond to incidents of domestic violence or sexual assault or abuse. So all of the different layers that we talked about earlier come into play, but certainly immigrant victims do have access to these systems. How well they respond in some ways depends a lot on us and additional education and favorable policies. As Luis says in the chat, this policy to support immigrant survivors will support those who are considered illegal. And with President Biden's new policy supporting illegal immigrants, this will be awesome. Yes, as we can support everyone. I agree, Luis. We try to say undocumented or non-citizens rather than illegal because we believe that no human being is illegal. But I agree with you. The news today is very good for all non-citizens, and we hope will be implemented in a way that protects immigrant survivors as well. Let's go to the next slide, please. Thank you. Now I'm turning it over to Leah.
So we'll start talking about some forms of immigration relief. And if we go to the next slide, there's a graphic that's a little bit difficult to read on screen, but I'm dropping a couple links. So the first one is a larger version of that same image. The second one is a version from DHS and includes links to, we'll be reviewing some of these forms of relief. We won't be covering asylum or SIJS, which is for certain children who were abused, neglected, or abandoned by one or both parents. And if we go to the next slide, we'll start with VAWA. So VAWA, as Christina mentioned earlier, stands for Violence Against Women Act, but it is available to people of any gender as long as they meet the requirements. The benefits of this are that there is a way to obtain legal, lawful permanent residency or the green card without having to rely on the abusive spouse, parent, or child. And this is essentially because it's a process that takes the place of the equivalent family petition process that would have been available to them if their abuser would have petitioned for them. A VAWA self-petitioner can also get work authorization, either upon approval of the VAWA self-petition and or with a pending application for adjustment of status or that green card. They can also include what's called derivatives, which is basically having benefits for certain family members. In this case would be children who are unmarried and under 21 years of age, whether they're living in the US or abroad. And just flagging, if someone's filing as an abused parent, that they're abused by their child, they cannot have derivatives, but for abused spouses and abused children, they can. The actual process of filing this and for adjustment will depend on whether the abuser is a US citizen or lawful permanent resident, and that's that shorthand of USC or LPR. Next slide, please. So what do they have to show to be able to apply for VAWA? So one is, the most important perhaps, is showing that they have a certain qualifying relationship with the abuser. So you'll see here for spouse or children who were abused, the abusive spouse or abusive child must be a US citizen or LPR, lawful permanent resident. For an abused parent, that child, adult child, has to be a US citizen. There is no category for an abused parent of a child who's a lawful permanent resident. Perhaps inherent in that is showing the abuse. And so the language used is that they suffered battery or extreme cruelty. So battery encompasses many forms of physical abuse, whereas extreme cruelty is generally non-physical abuse, emotional, mental harm, to show that they were abused by this individual. They must also show that they lived with their abuser. And that they themselves, a self-petitioner, have good moral character, essentially that they are a good person, haven't committed very serious crimes or other reasons that USCIS should deny their petition. For anyone filing based on marriage, so that spouse of a US citizen or LPR, they have to show good faith marriage as well. So not just a legal marriage, but good faith, which means basically that they didn't marry just to obtain immigration status or otherwise circumvent immigration laws. Because in USCIS's mind, every marriage is fraudulent unless proven otherwise. And as you recall, this process is taking the place of that family petition, so they still have to show it was a good faith marriage. Next slide, please. Some other details to note. So even though good faith marriage is a requirement, that presumes a legal marriage. Common law marriage can meet this requirement as long as it's legal where it took place. In addition, even if someone divorces from their abuser, they can apply with as up to 2 years after that divorce, if they can include evidence that the termination of the marriage was connected to the abuse, which is generally not super difficult to show, but is a required showing. Note that anything after that 2 years, there is no exception for that. Another thing to keep in mind is that while many self-petitioners are filing within the US, there is this possibility to file from abroad if they meet one of these 3 exceptions. So either their abuser is an employee of the US government working abroad, is a member of the uniformed services serving abroad, or the self-petitioner was subjected to abuse while they were in the United States. I do see a question. Oh, I see Christina's typing an answer, but I do see a question of what if the marriage was forced or coerced? It's a very interesting question and has come up, and I believe Tahereh has some resources on that. It's interesting enough, USCIS website does, on the language of like forced marriage, reference VAWA and other forms of humanitarian relief. The policy manual, which talks about VAWA, does not discuss that at all. The good faith marriage requirement is what the intent was at the time of marriage. So for example, while it's not the same at all, arranged marriages are not excluded from being potentially eligible for VAWA. With forced or coerced marriage, they're demonstrating that their intent to marry was not to circumvent immigration laws and can be proof of the abuse, the pattern and cycles of abuse. And so you have heard of these cases. I can't say that I specifically know what the outcomes have been or how USCIS has treated this, but there at least is this possibility USCIS acknowledges that this person should be eligible for VAWA. And I think I'm passing to Christina to talk about cancellation.
Oh my, hi. So remember at the beginning, I talked a little bit about the different agencies that can adjudicate immigration relief. VAWA cancellation of removal. First of all, what Leah just described is a VAWA self-petition, and that is an application that is made to USCIS, and that is considered an affirmative application for relief. VAWA cancellation of removal is what's known as a defensive application for relief. It is made currently, it is only available in immigration court. So when a survivor is in removal proceedings at the Executive Office of Immigration Review before the immigration court and is trying to ask the court not to deport them, they can ask for this form of relief called VAWA cancellation of removal. They can also ask at the same time for asylum or any other form of relief from removal that they are eligible for. VAWA cancellation of removal is a waiver, basically a waiver of inadmissibility, or a waiver of the basis for being placed into removal proceedings. It is only 4,000 approvals are allotted per year. The backlog is currently 3 to 4 years for VAWA cancellation of removal approvals. But you can still be approved, for grants. If it's granted and there is one of these 4,000 case numbers available, that person immediately becomes a green card holder. So they don't have to wait or do anything else in order to get their green cards. If the case is granted and there is not a case number available, then the case will be placed on hold until a number is. That's where we see this backlog. VAWA cancellation is very similar to the VAWA self-petition, but there are a couple of different rules that I talk about on the slide here. There is additional eligibility for an unmarried parent of a child abused by a citizen or green card holding parent. This is for people who are not married, so where they don't have a legal marriage in place, but they are partnered with an abusive US citizen or green card holder who abused their child, a child that they have in common, or a child that they have. That is one uncommon use of the VAWA cancellation of removal. Makes it uniquely available in removal proceedings for people in that posture. For other eligibility requirements are that they must be continuously present for 3 years prior to filing for relief. And there's a special rule here for military connected survivors, that 3 years continuous presence requirement. They're exempt from if they honorably served in the US Armed Forces for 24 months. And were in the US when they enlisted. In other words, they can't have enlisted from some other country. Another exemption or another wrinkle here for military connected survivors are that periods of absences from the United States that would otherwise break their presence, that is like 180 days or 90-day absences, otherwise for non-military connected survivors would break this 3-year period of continuous presence. But for military, if those absences will be excused for, I guess the language of the policy of the manual is certain military service. But if that you think that may apply to someone that you're working with, definitely let us know. We can get some additional details on that for you. But ultimately, this means that participating in military service abroad will not necessarily be a barrier to VAWA cancellation of removal. And VAWA cancellation of removal is available to abused survivors who have been divorced for more than 2 years from an abusive citizen or green card holder. And that is another reason why it is very good to know about VAWA cancellation of removal, particularly for people who are in removal proceedings. They may not be able to file for VAWA affirmatively with USCIS, but they may still be eligible for relief from removal. Next slide.
Now we'll talk about the U visa. So the U visa has dual purpose. It's to strengthen the ability of law enforcement to detect, investigate, and prosecute criminal activity. And it's to offer protection to victims of these crimes in keeping with the humanitarian interests of the United States. So here on the slide, you see the benefits of the U visa. So upon approval, there's 4 years of work authorization granted. Through this process, principals are the ones who apply. They can also include derivatives, which are certain family members, whether they're in the US or abroad, to also have U non-immigrant status. And then once their U visa is approved, after 3 years of continuous presence in U status, they are eligible potentially to apply for a green card as well. There is this interim process because the wait list is very long right now, the wait for it is very long right now. It's at least 7 years and likely much longer for those who are applying now. There is this interim wait list or bona fide determination process. So that's where an application is reviewed. They can fall under one or both tracks, but the initial review is for the bona fide determination or BFD. If granted, they also get that work permit for 4 years and deferred action status, which means they should not be priority for removal or enforcement action, barring any significant change like criminal history or other reasons. Unfortunately, though, while there is technically a process that could be available, there is no designated path right now for family members abroad to enter when this determination is made while they're waiting out the actual adjudication of the U visa petition. Next slide. So that principal petitioner must demonstrate certain things to show that they are eligible for the U visa. So they have to show they're a victim of qualifying criminal activity, which we'll discuss in a little bit. And they have to show that crime occurred in the US or otherwise violated US law. And generally that second part isn't that anything equivalent in another country would suffice. It has to be a violation that allows US to have what's it called extraterritorial jurisdiction over the prosecution of that offense. They have to show that they suffered substantial physical or emotional harm as a result of being a victim of that crime. And they have to show that they are, were, or could be helpful to law enforcement in that investigation or prosecution of the crime. And all those requirements that I just listed, the principal has to show, the derivatives do not. They do not have to meet this requirement. They're just tagging along onto the petition. However, all who are filing for U non-immigrant status must be admissible or eligible for a waiver if they violated any of the laws, immigration laws for admissibility. Next slide. So it's not enough for the petitioner to say that they were a victim of a qualifying crime and that they were helpful and that the crime occurred in the US, like certainly they can, but the petition cannot be filed without a 918B or this law enforcement certification. This certification is by an agency that's essentially signing and confirming that the petitioner was a victim of a qualifying crime, that crime occurred in the US or violated US law, and that the victim was or is likely to be helpful. So which agencies can certify? You see a list on your screen here. It can be at federal, state, or local levels. So typical forms of law enforcement, you think of like police or sheriff, prosecutor. It also includes judges, also investigative agencies. So like Child Protective Services, Labor Relations Board, Department of Labor, and military entities can certify as well. So that's the agency level of who can certify. And then there's a second factor of who within that agency is allowed to sign the cert. So per the regulations, the head of that agency could sign, someone in a supervisory role who's specifically designated by the head of the agency to sign, or if someone's a judge at the federal, state, or local level, they can sign the certification as well. Next slide. So as promised, here's that chart of qualifying crimes that can make someone eligible for the U visa. So if you're looking at that, what comes to mind as you're looking at this list? Are there crimes you don't see on here that you think should be included? What crimes are here that seem like they're domestic violence crimes but aren't labeled as such? Or what crimes aren't on here that come to mind that you've seen in domestic violence cases? And while people are chatting, I'll also point out that this also includes similar crimes, attempt, conspiracy, or solicitation to commit any of these crimes as well. Would reckless endangerment qualify? I think that's an interesting question. I think so. One thing to keep in mind too, which is worth pointing out, is so these are general categories of crimes. And so you will look at the statute in play, essentially. So if we're talking about the state, we'll look at that statute. And so a lot of states, for example, do not have specific domestic violence statutes. They'll have assault or battery and like a domestic violence qualifier, for example. And so reckless endangerment, depending on whether the state says, hey, if it occurs within these types of relationships, that is considered domestic violence. Is this considered child abuse? Is that similar to domestic violence? So it really depends on the statute or potentially the actual facts. There are two different analyses, which is way more detail than to go in right now. So potentially could qualify, but it really depends not only on the state statute, but what the underlying facts are to make the argument that if it in and of itself, USCIS would not say it qualifies, maybe it's similar enough to domestic violence, for example, or the attempt to commit one of these other crimes that yes, it could make someone eligible for the U visa. All right, and so one thing to point out as well before moving on is here it doesn't specifically list child abuse, elder abuse. And so again, for those we want to look at the state statutes and the facts to say, hey, even though it's not a category specifically named under this list, this person is still eligible and here's why. And just flagging here, which is why it's also good to refer someone to do this analysis because sometimes it's really not as straightforward as we would love it to be. Next slide, please. All right, so the T visa also has a dual purpose, very similar to the U. So it's one, to strengthen the ability of law enforcement to detect, investigate, prosecute severe forms of human trafficking. And this is usually labor and sex trafficking. And also to provide protection to victims of severe forms of human trafficking. Here are the requirements. So again, this is what a principal petitioner would have to show, that they are a victim of severe form of trafficking. One thing to keep in mind, this is federally defined, and there are a lot of confusing details of what makes someone eligible. And even within the definitions, there are other definitions. And so that'll be its own analysis we won't go into, but someone has to show they fall under one of those categories, that they are here within the US physically on account of the trafficking. And just quickly mentioning, this does not mean that they were trafficked into the US. They could have come to the US any other way and were later trafficked. And as long as they're still here because of that trafficking, that will show that they met this element. They also have to show they complied with any reasonable requests to help in the investigation or prosecution of the trafficking. But unlike with the U visa, that signed certification is not required to file the T application. They also have to demonstrate, unlike the U visa, that they would suffer extreme hardship if they had to return to their home country. Like the U visa, they can also include certain derivatives, whether within the US or abroad, and they are also eligible to apply for adjustment after a certain amount of time in T visa status. Next slide. So we're back to our hypo for Laura. So this is a repeat of what Christina read earlier of the facts provided to you. And so I'll review quickly, but as we're reviewing, what more would we want to know here? And so put your ideas in the chat. Remember, Laura is from Honduras, came in 2013 with her 7-year-old son, met Robert, an Army private, had a child with him. And we know that she left after an abusive incident where he hit her in the face in front of the children. So what other questions do you have here for Laura or us, I guess, as the hypo developers, but what else would you want to know as you're trying to figure out how best to provide assistance to Laura? I'll do it. Give me, I accidentally slipped up and said they were married, and we don't have that fact. So one question is to know, were they legally married, or otherwise, is there a way to say there was a legal marriage here? Are they common law married if they're not legally married? Is Laura willing to report to law enforcement and also to make her aware CPS would be notified? I think that's an interesting point as well. The fear of not seeing her daughter is keeping her from calling the cops. Yeah. So the common law marriage could go potentially to eligibility, right? We mentioned VAWA, there has to be this marriage. About reporting, I think those are important questions, especially depending on what form of relief she might be seeking. And here might be very helpful to loop in an immigration practitioner. So remember, for the U visa, that law enforcement certification is required. VAWA doesn't require anything similar, right? And so somebody mentioned the fear of not seeing her daughter might be keeping her from reporting, or given that CPS would be notified, that might deter reporting. There might be a way that she doesn't have to report at all to get immigration relief. And so that's something to loop in. Also, like safety planning, there could be a lot of concerns for her and her child. Again, in these facts, we know that she left for her friend's house. We don't know that she took her daughter with her, right? And so that's something to keep in mind as well. Somebody mentioned she can utilize the Army FAP to report the abuse. Interested in knowing more about that. Somebody mentioned that's a great resource, the FAP or a chaplain. Being a military spouse, victim advocates should emphasize a restricted report, as this can help her initially. Yeah. Also mentioned, like, we don't know Robert's immigration status. Like, we might all be assuming it's US citizens. So that's another thing to keep in mind. We want to know how she entered. Was she married before? So a lot of great comments from y'all. The FAP is the Family Advocacy Program. Thank you, Tiffany. And a lot of good catching of these red flags, right? Of why she might be concerned about reporting, where she might be able to report to have a restricted report. So these are great options. Thanks, y'all. Next slide. So here we had our additional facts, right? So here's where we find out Robert's a US citizen and they did marry shortly before their child was born. She tells you she did make that report and he has an upcoming court date because he was arrested. She mentions she was arrested and convicted of assault because they saw scratches on his arms when she had been trying to stop him from choking her. And she also tells you about when she crossed the border and that she learned she had a court date in immigration court, but Robert told her she didn't have to go because she was married to him. So here again, what are you noticing? Are you noticing any red flags? And what steps would you take as an advocate? And as flagging, Luis mentioned, restricted reports help victims prepare to contact law enforcement, and that they help victims with this in similar scenarios. That's great to know. Thank you. Abuse occurred in front of the children, so this would be reported to CPS, and the case would be allowed to be kept restricted at our base. Good to know. I would ask if she felt safe where she was and provide her with resources on and off post so she can make an informed decision. That's really great to give the information so she can make that decision that's best for herself. Oh, sorry, it wouldn't be allowed to be kept as restricted on our base if it was reported to CPS. Thanks for the clarification, Lupe. Right. So here too, I'll point out, we have that she was convicted of assault. And so here, I don't necessarily want to call it a red flag, but it is something that we want to note and know more about potentially, right? We also have here that she crossed the border and got a piece of paper. That's likely something called an NTA, or notice to appear in immigration court. And it seems like she had a date. As far as we know from this wording, it probably passed. And so that can be a concern that she might have a removal order, what's called in absentia, or while she wasn't there, that they ordered her removed. And so these are things that as we go to the next slide, we'll want to explore more. So let's do that. Let's go to the next slide. So these are steps to take with Laura. So remember, she received that piece of paper and didn't go to removal proceedings. So likely that piece of paper, or if she has any other immigration documents, will have what's called an A number. Unfortunately, that does stand for alien number. So we just shorthand A number. And you'll need that to either call this number, and it is all automated, you don't speak to anybody, or to plug it into the online case information. And that'll pull up either when the next hearing is, if she didn't miss it, or will say what the outcome was of her hearing. And so that will at least get her information so she knows what happened in that case. Another thing, as somebody mentioned, is remind her of the pictures her friends took as evidence, that she has them and can utilize them. So one thing that's really important is helping survivors gather the documents they need. And more importantly, sometimes is storing copies, right? If they at this point can't safely keep things, or they're concerned the abuser will find them or destroy them, it can be really vital just to say, okay, send me this over email if that's safe to them, or making copies of documents they can gather so that there is a backup option. So for example, somebody mentioned those photos of her injuries, copies of the police reports. We know that she made one, and it also sounds like there was one made against her, even though she called because he was choking her. Court documents as well. So we have, like, he's currently in court, so there might be a criminal complaint, even though the case hasn't really started, but we also know she was convicted. And so getting a copy of those documents can be helpful as well. And oftentimes, either for language reasons or just discomfort with interacting with these different agencies, a survivor may not want to go and ask for a copy on their own. Do want to flag here, even though we didn't discuss it, that where someone needs documents from their country of origin, be very cautious about this and maybe don't seek copies if they are saying they're afraid to return. It gets really complicated into like asylum and other similar forms of relief, but if they need a copy of a passport, national ID, or birth certificate, but they say, hey, they're afraid to go back to their country, it might be worth not seeking those copies and waiting for an immigration attorney to determine if there's a safe way to do so. Knowing where to refer will be really important. So I'm going to drop a link that we share often. It's the Immigration Advocates Network, has a legal services directory, and you can choose by state, and it'll list what organizations are available and also say what their like focus areas are, and that can be really helpful. And again, collaborating as much as possible, as much as the survivor and attorney can permit, given confidentiality, privilege, and just other concerns. And safety planning, as many of you mentioned, is so important, right? So that she can make the decisions that'll keep her and her child or children as safe as possible. And I'll pass to Christine.
Thanks, Leah. All right, next slide, please. All right, in this section, we're going to cover a few of the immigration policy changes that have taken place over the last several years that impact immigrant survivors. Let's start in the next slide. Okay, so the first has to do with notices to appear and the initiation of immigration enforcement action for survivors who have filed VAWA petitions, U visas or T visas affirmatively with the USCIS. In the past, we felt more comfortable, I would say, assuring our clients that our legal clients that if they filed for one of these forms of relief, that they would not be, and their applications were denied either because possibly they did not meet one of the eligibility criteria or could not demonstrate that they met one of the eligibility criteria, or they could not overcome a ground of inadmissibility that needed to be waived. We could assure them that they would very likely not be placed into removal proceedings. This changed in 2018 and 2019. So we can see here that the July 2011 policy was that applicants for VAWA, U, or T applications would generally not be placed into removal proceedings or referred for immigration enforcement if their applications were denied. That was the policy that allowed us to give these assurances, because there were agency practices that really backed this up. In 2018 and 2019, that changed. There were explicitly the agencies that were adjudicating these, that USCIS specifically, and was explicitly instructed to not apply these protections if applicants for VAWA, U's, and T's were denied. It also authorized ICE to initiate removal proceedings against immigrant survivors whose petitions were denied or were just pending. So that assurance, which was a very important piece of encouraging survivors, immigrant survivors, to come forward and file for relief, for immigration relief, those assurances, we could not really make them anymore. In 2021, those memos from 2018 and 2019 were rescinded, and the 2011 policy was reinstated. Later in 2021, in August, ICE released, or the Department of Homeland Security released the ICE Victim-Centered Approach Guidance, which advises agents of the Immigration and Customs Enforcement not to initiate enforcement actions against known survivors. And that has, I think we would say, mostly been applied consistently, favorably for survivors, except that survivors who have a history of criminal legal system contacts are sometimes treated differently under this guidance. So I guess the takeaway here is that because of all of these changes, it's been a bit of a roller coaster for survivors and their advocates as far as how to advise them about the likelihood of eventual immigration enforcement against them. However, that said, we're moving back towards a regime in which there is greater security for people who are filing these applications for relief. I think we can more safely than we have been able to in years advise survivors that there will likely not be placed into removal proceedings if their applications are denied. Like I said, this was hugely important for clients that I had back in the day who were concerned about getting deported. As we saw, that was a very effective tool for abusers, is threats to deport. And so these assurances are back in place. They're not as strong as we would like them to be, but they do. Next slide. Thank you. Okay, so there are some benefits that were specifically adopted for military connected family members and ex-military and members of the military. These are not specific to immigrant survivors. They're not specific to survivors at all, but they are helpful to survivors, I would say. In 2021, the Department of Homeland Security and Veterans Affairs started this program that the acronym of is MVI, Immigrant Military Members and Veterans Initiative, which coordinates the special military benefits for immigrants, including naturalization, deferred action, and parole for military-connected immigrants and their families. I did not include naturalization here because that is a longer conversation, it's outside the scope of what we intended to cover today, but I'll put here a link in the chat to the USCIS policy manual page that covers all of these benefits that are related to military service. I mentioned deferred action. That's something that I think we're hearing a lot about if you're listening to the news, if you're listening to also, if you know about DOC, you hear these words, deferred action. Deferred action means protection from immigration enforcement and removal. It means that if you have a notice of deferred action, you are eligible to apply for work authorization and to obtain certain public benefits. Parole, similarly, that's something that's been in the news in the past day or two. Parole in place or parole means specifically admission to the United States. It means that you have a proper admission once you are granted parole in place. Parole in place for military members of the military and their families is a program that has been in place for many years. It is a very common form of relief that's sought for family members of the military. One thing I will say about it that is very helpful for survivors in particular is that, as you can see in the link that I shared, it's not on the slide, but applicants who are family members of people serving in the military can apply for parole in place without, on their own. They can file their own Form I-131, which is the form that's used for this application, and the documentation proving their relationship with a member of the military. So for survivors, this is going to be a particularly helpful form of relief because it initially allows you to, establish your presence in the United States and apply for work authorization. There's a helpline that's here on that bottom of the slide. I'm starting to get a little nervous because we're running a little short of time. So I want to move on from this, but these benefits, although they are, again, not specifically for survivors, can be very helpful for survivors. And not all immigration benefits that survivors apply for need to be survivor specific, of course. But so given the topic of today's presentation, I wanted to cover these for sure. But let's go to the next slide. Public charge, that was another policy that was adopted by regulation during this administration that we're still in. In September 2022, regulation was issued that defined public charge as it had been defined in previous administrations, but now in regulation that someone who is inadmissible for being a public charge, that definition is limited to those who are primarily dependent on the government for subsistence, either in the form of public cash assistance or institutionalization for long-term care at government expense. So people who are temporarily on food stamps are not considered to have violated the public charge ground of inadmissibility. Generally speaking, immigrant survivors who have or are applying for UT or VAWA status are not subject to the public charge ground of inadmissibility at all. These links here on the slide provide additional information, and the link for referring to the NUWAP NIWAP Public Benefits Eligibility for Immigrant Survivors charts has state by state information about public benefits that immigrant survivors are eligible for, regardless of immigration status. Next slide. And Leah's going to take us through the fee rule quickly.
Yeah, so earlier this year, there was a final fee rule issued. And this importantly contains a lot of fee exemptions for the forms of relief we discussed, and that SIJS for certain abused children, where they are just fee exempt entirely and do not need to file for a fee waiver when they submit their forms. Want to note there's no fee exemption specifically for naturalization or that certificate of citizenship, so that N400 or N600, or the I-90 to replace or renew the green card. Fee waivers are still available as they were, and the fee rule did expand eligibility for the reduced fee option for the N400 or naturalization application, and that reduced fee was expanded to those with income up to 400% of the federal poverty guidelines. Back to you, Christina.
Thank you. Let's go to the next slide now. Okay, we're going to talk about know your rights and safety planning. Although I think I'm going to move quickly through my slides here so that we can talk a little bit more about the role of advocates and how you guys can help. These are the images on the slide are of resources that are available to advocates and just members of the public and interested people for helping to prepare immigrant survivors and immigrant non-citizens in general to avoid immigration enforcement and to take care of their families in the event of separation or immigration enforcement. And Marisol, you will get a slideshow emailed to you, I believe, by Nova. Thanks. Next slide, please. Again, I'm going to allow folks to take a look at this slide on their own. I think we've covered some of this material already, and we'll get into it a little bit more in the last couple of slides. So let's go to the next slide, please. And links to resources. These were the documents these links go to the agencies that prepared the documents that were on the previous slide. So there you have it. Next slide, please. And what should survivors carry with them? I believe this is Leah's slide.
Yes, so just wanted to quickly flag. So importantly, they should know the contact information of an attorney or legal representative. Carrying it should be fine. If possible, the ideal would be that they memorize the number in case they're not given access to what's in their wallet or what have you. We'll talk a little bit about that Know Your Rights card that they can show. And most importantly, if they have a valid ID, whether that be a license, identification card, work permit, green card, they should carry that. They should not carry false documents at all, ever, as much as they can avoid it. And ideally too, so with the work permit or green card that's showing some status, I know there are also hesitancies if they're carrying like an ID that is from another country. If they were stopped and that was obtained, that can be something that they use to say, well, clearly this person is a foreign national and therefore they have jurisdiction over them. Next slide. So that Know Your Rights card or red card is what on the screen here. This can be ordered from ILRC, and if you're at a nonprofit, it should be free. And so this is something that they can show. It has English and Spanish, and it is available in other languages as well. To say that they don't want to talk, basically enforcing their rights, ideally can practice with them too, because the hardest thing is not just knowing your rights, but actually enforcing them in some way. And that can be very nerve-wracking to do when you're dealing with law enforcement. And so this can help them to hand this to whatever officer they're interacting with as well. Next slide. And so we really wanted to emphasize once again how important of a role as advocates we have to helping them with this. Like they are often dealing with multiple systems. So here we're talking about the military, we're talking about immigration, we're talking about police, we're talking maybe family law and orders of protection. And this is a lot that intersects intersects and overlaps and sometimes conflicts. And so understanding what they have to do for each step, it can be so vital in getting them to know, hey, this is the process available to me. Here are the decisions I can make and what the consequences or outcomes might be. As many of you mentioned, there might be fear of reporting to law enforcement. If there's a way to negotiate that, to either assist them in making that report or be there with them as they do, that can be so helpful. Explaining what confidentiality means, what the limits there are to that. Many of you, again, also flagged CPS, like mandatory reporting. That'll be really important for her to know as well, and her and our hypo. But for any survivor, what their rights are, safety planning, again, as many of you flagged, and then also helping not just to find immigration representation, but helping them as they are pursuing immigration relief in ways that we talked about, evidence gathering, perhaps letters of support, helping them frame the story, findings like support services, whether that be a counselor, therapist, can be so vital and goes beyond what many immigration attorneys might be able to do in their role in this process as well. And again, I think we mentioned already, corroborating the non-physical violence, identify and creatively collect supporting documentation. And again, we have that directory, and you can also reach out to us with any questions. And relatedly, in our next slide, is how we can help. So we have our emails on this slide, but we do provide technical case assistance, so help with individual cases. So if there's a specific issue or question, we can help discuss that, identify what options might be. And also there are additional trainings. So there's some on our website, NOVA, and our own webinars, and then Clinic for those who are seeking like BIA accreditation. Clinic does offer those resources as well. And so we've talked a lot. Are there any other questions you'd like to see those pop up in the Q&A? I know there was a few questions about the slides that will be emailed, but thanks y'all. And let us know if you have any other questions.
Or any other comments about the different kinds of roles
Yes.
that y'all can play to support immigrant survivors.
All right. Well, I don't see any outstanding questions in the chat or Q&A. I do want to thank you both so much for an amazing presentation, such great content that all advocates should be aware of, whether they are military, community, or systems-based. So we sincerely appreciate your partnership. And I hope for everyone here today that this content just sparked your curiosity to learn more, to enhance your services for immigrant survivors and military connected. Please feel free to reach out. We do also have a survey for you for this webinar. We do encourage any feedback. I'm going to post that in the chat. And please ensure when you're completing the survey to spell your name correctly. That's how the certificates of attendance will be written out. So double check and cross check those. Also, we're going to be sharing a link to the slides. Thank you, Kimberly. So to download the slides, please go to that Google link. Unfortunately, we had trouble dropping it into the actual chat as a document, but please click on that link and that'll give you access to the PDF. Thank you so much for attending. I hope everyone has a great afternoon and evening. I will stay on till 30 after the hour if there's any outstanding questions or comments. There is also a resource handout. Kimberly, were you also able to put that in the link? Let me see if I can find that. Yes.
Thank you to our ASL interpreters.
Yes, thank you so much.
Thinking the same. Thank you.
All righty, well, that's it for all the questions and chat. I see a lot of thank yous. Thank you again to Assista. Hope everyone has a great evening. Bye.